Recording starts.
Good evening, everyone. My name is Lucy, and I would like to welcome you to the webinar on condominium law in Quebec. We'll get started in just a few minutes as we let more people enter the room. In the meantime, I just want to go over a few items before we get started. For the best experience with so many of us on this call this evening, we recommend that you disconnect from VPN and close any unnecessary applications. We also ask that you keep yourself on mute for the session so that we don't disturb the speaker. There will be a question period at the end of the session, so we ask that you keep your questions to the end. You can type them in the chat, which is located at the bottom of your screen, and I will review them and collect them, and we will answer them as best we can at the end of the session. Finally, I just want to remind everyone that the session is being recorded. So you will receive the recording as well as a copy of the presentation within a day or so. Now, I would like to take a moment to acknowledge and thank the Chambre de Commerce, the Notaire, for their support and for making this webinar possible. Contributing to the excellence of notarial practice, encouraging the continuous development of law, and promoting access to preventive justice are all missions of the Chambre des Notaires that drive its overarching objective of protecting the public. Legal advisors focused on conciliation. With so much information available out there, notaries are key public officers who can help the public understand what they need to know, make the best decisions, protect their patrimony, and ensure that their wishes are known and respected. And now I have the pleasure of introducing our speaker for this evening, Maître Sébastien Fisset. Maître Fisset is a lawyer and a member of the Quebec Bar since 2002. He has over 20 years experience in real estate business, specializing in co-ownership law. He also has extensive experience in the management and administration of condominiums, having previously been a condominium manager for a property management firm. He currently is the managing partner and founder of Fisset Legal Law Firm since 2009, and is also an accredited mediator and arbitrator in civil law disputes in the fields of real estate, co-ownership, and construction litigation. He has authored several texts on real estate law, is a conference speaker, as well as a course lecturer at McGill University School of Continuing Studies. So now, without further ado, I pass the floor on to Maître Sébastien Fisset.
Thank you, Mrs. Bernetti. Good evening, everyone, and welcome to this, let's call it, crash course on divided ownership. Tonight, I hope to help you out to figure out a little bit how it works. There's an agenda. We'll not exactly follow the items in the agenda, but we'll get through most of the points that are there tonight, either with the slides or through comments that we'll make. So without further presentation, let's move on to point one of the presentation for tonight. So general concepts of related to the divided ownership. Of course, tonight I will give my conference regarding divided ownership, but you need to know first what is a ownership. So basically, there's an article in the Civil Code of Quebec which refers to the modalities of ownership. It's Article 1010 of the Civil Code of Quebec. By the way, each and every article you will see in this presentation, you can type online on Google or Bing or whatever, Civil Code of Quebec or Code Civil du Québec, and you will get to many websites where you're going to be able to read those articles and many others that will not be mentioned tonight. So a ownership, if we look at that article and a definition of what is a divided and undivided ownership. So we can read a ownership is ownership of the same property, jointly or concurrently. Concurrently, we can think, for example, time sharing by several persons, each of whom is privately vested with a share of the right of ownership. Now, like I said, there's two types of ownership. So there's the undivided ownership and there's the divided ownership. When we talk about the undivided ownership, like it says there, it says where the right of ownership is not accompanied by a physical division of the property. What does it mean? It means that, for example, we'll see this later on. I can very quickly go to further slides. you can see here is the cadastral plan of a divided cornership. Well, if we look at an undivided cornership, there's only one land with what lot number. There's only one tax account for the full building. There's also only one big lot numbers, and everyone is living in different dwellings or unit, but they're not the owner of their unit. They're the owner of the full building with a right to live in one of the dwellings of the building. Let's say that it's a dwelling. If it's a commercial, then commercial also. But mostly we see this in dwelling and units for living. Now, if we refer to subject for tonight, divided cornership. So divided cornership, amongst other things, it's a building separated into common portion of the building, private portion of the building, and common portion for restricted use, which we will define later on tonight, actually in a moment. So first thing, components of a divided ownership. The private portion. The private portion, when we refer, for example, to a typical tower, a typical building in ownership with many units, one over the other on many floors, the best definition I like to give to the clients or to the students at McGill University is giving the comparison with an aquarium. So if we refer to the frame of the aquarium and we think about by analogy to a building, well, the frame of the building is a common portion of the building. Now, the space of air where the owner is living, his private portion, the dwelling, his parking spot, if there's a place where he puts his belonging outside of his unit, will also be sometimes considered as being a private portion of the building. So the image I like to give is the aquarium. So basically, there's the frame, which is common portion, and there is the private portion, in the case here, the water. And sometimes I say this to some people that are meeting with me, and basically you're the fish who bought that aquarium. This being said, the common portion of the building. So we talked about the private portion of the building. The common portion of the building, most of people think that common portion of the building is the property of the Syndicate of Ownership. That's a mistake. The common portion of the building are the property of all the owners according to the relative value of their fraction of ownership, if you want, their share of the building. I like to give as an analogy also, if we think about having a picture together where we will put a little bit of our own juice, which are our private portion, and we put it in a jar, and that jar is the common portion of the building. Well, you do understand that if we put this in a jar, and that, for example, I have orange juice, somebody has got the grape juice, another one peach juice, and then another one grapefruit juice. Once we put it all together and that it becomes common portion of the building, nobody can decide to put sugar in it. Nobody can put a straw, nobody can, it's the common portion of the building. I like to give this analogy so that you understand that you cannot, for example, put a satellite dish on the outside of the building because it's not your property. It's the property of all the corners. You're just one of the corner, and you are the owner according to your share, or if you want, according to your relative value of your fraction of ownership. But the Syndicate of Ownership, he's not the owner of the common portion of the building, but he's the one who will administer the building for the collectivity of the owners. Now, common portion for restricted use. They are common portion of the building. So it means they are the property of all the owners, just like the common portion. However, they are to the restricted use of some of the owners. For example, a balcony. For example, sometime a parking spot if it's not having a lot number different. For example, windows of your private portion, they are common portion of the building, but for your restricted use. For example, normally the door that brings you inside your unit is also a common portion for restricted use. You have the use of it. According to the law, you're supposed to pay for the maintenance and the minor repairs, and the Syndicate of Ownership will, through the contingency fund that we'll see later on, pay for the major repairs and the replacement of those common portion restricted use, just like for the common portion. But for the common portion, the syndicate, through the budget or through the contingency fund, will pay everything. Now, it's not because you pay for the maintenance or for the minor repairs that means that you're going to do it. In order to know if you need to do it on your own or if the Syndicate of Ownership will do it for you, you need to look into the Declaration of Ownership. We'll have a little glance later on regarding what is a Declaration of Ownership. I'll show you the old version of Declaration of Ownership prior to 1994, which is the Civil Code of Quebec, the new Civil Code of Quebec. Before that, it was called the Civil Code of Quebec was the Lower Civil Code of Quebec was for the province of Quebec. So basically, this is for compulsion for restricted use. I wanted to compare with, let's say you have with I don't know, with your friend or with your spouse or with your girlfriend or boyfriend a car. If you bought the car together, you have the right to put dice if you want, but you cannot change the color of the car. So it's not because it's to your restricted use that you can decide to use it as if it was your property. It's not your property, it's the property of everyone, but you're one or some of you having only the restricted use and not the other. So basically, when we look at this picture, there's a lot of things on the balcony. Most of the time, the Declaration of Ownership will have stipulation to provide that the building doesn't look like a Christmas tree or so. Now, when we talk about components of a building, so private portion, common portion for restricted use, I wanted to give you a glance of one of the two documents that lawyers or notary will look at when they want to study or analyze a building. One of them is the cadastral plan, and we have one here and here. I'll in a second explain a little bit to you what is the cadastral plan, and the other one is the Declaration of Ownership, with which I will talk a little more about it following explanation about the cadastral plan. So this is a cadastral plan from a building, and if we look at it, for example, we can see on the right side that it's the shape of the building. It has no real legality, but it's to help you or for the person analyzing or studying the cadastral plan to help him understand what the shape of the building looks like. Now, what is the cadastral plan? It's the delimitation of all the lots, and they're published at the Land Registry Office. This document is published. It's accessible. If you have a credit card and you go on the Land Registry Office online, and that you learn how to make a search, then you're going to be able to access to, for example, the cadastral plan of your Syndicate of Ownership or another one, because those documents are public, so everybody can have access to them. So now, for example, if we look at this building in particular, we see 1407-1 and -2. If we look in the Declaration of Ownership, there's 3 sections. There is the Constituting Act, or the Act constituting the Declaration of Ownership, which is the first part of the Declaration of Ownership. The second part, which is the Bylaw of the Immovable, and the third part, which is the description of the fraction. I'll explain this to you a little bit afterwards, what are the differences. Just wanted to let you know that when we look at that number here, we have 1407-1 and -2. I know in advance that these are the common portion of the building. While if I look on the left side of the screen, I see, well, we cannot see it because it's a little bit small, but if we would be able to focus on it, we'll be able to see that these are other numbers than those 2 numbers, and they have different numbers, and each and every private portion of each and every ownership, divided ownership, will have a different lot number for each and every private portion of the building, and normally 1 or 2 for the common portion of the building. So basically, for example, if we look at this here, it's normally like a Google Earth view. If you look from the sky down, you see that it's the top of the building, and then you see that in the back there are some private portion. And for me, I know these are parking spots. So, for example, if we look at another cut of the same cadastral plan, because there's cuts of the building both from up from the sky down, or also from the side of the building, and we can see all the floors of the building. For example, here we see the 4th floor of that building. We can see, if we look at the image, that it's that slice of the building, and we can see many lots. All those lots will have a different lot number, and these are private portion. If we go in the declaration of ownership, we'll see later on, each private portion, there's what I call it like a section of the declaration of ownership where all the lots number will be baptized. So it's going to be either a private portion or a common portion. As for the common portion for restricted use, they are common portion. Therefore, they will have the same lot number as the common portion. But in the declaration of ownership, we will come and describe and list what are common portion for restricted use of some of all the corners. Now, before moving maybe to the second section, which is the syndicate administration, I would like to show you declaration of ownership. So this is a declaration of ownership, like most of the declaration of ownership. So for example, we have the preamble, and if we look at it, I was telling you that there are 3 sections in the declaration of ownership. So here, for example, on page 2, we can see the first section, which is the act constituting the ownership. That's the first section of a declaration of ownership. So basically, this is, how can I say this? It's a little bit like the act constituting the Canada. So it will divide into 2 parts. The first part is they will describe what are the common portion of the building, what are the private portion of the building. Then we will move on to, and I will probably go very fast through it. We will afterwards, well, the destination of the immovable. It's a larger concept than it seems. I will not get into this today, but just wanted to, so that you have a glance a little bit at what is a declaration of ownership. Something very important for a syndicate of ownership and for the owners. There will always be a table in a declaration of ownership. Normally, it's close to Article 25 of the template of La Chambre des Notaires. And you will see all the units, their lot number, and their share of the building. So basically what I was referring to before, if we look at the cadastral plan, you will find the lot number and you will know what is the share of that private portion. If you're the owner of a divided ownership, you might have one or many private portion included in your fraction of ownership. What I mean by that is, for example, if you have a parking space, it's a private portion, just like your dwelling is a private portion, but both of them will have a different lot number. So then afterwards, just like the act constituting the Canada, you will have a division of power. Like federal government will have some powers, provincial government will have some powers. Well, it's the same thing in a declaration of ownership. We'll see this in a moment, but the board of directors has some powers of their own, and the annual general meeting will have other powers. In our system of law, most of the powers are within the hands of the board of directors, and the others, and I would say that mostly all of them, if not all of them, are of public order, and it belongs and it pertains to the annual general meeting of the owners. So basically, that's the first section of a declaration of ownership. The second part of a declaration of ownership, bylaws of the immovable. Basically, it refers to the aspect of living and enjoying the building, and restriction and condition in order to use the private portion of the building, the common portion of the building, the common portion for restricted use regarding, for example, wood flooring, ceramic. So many things like that will be considered in the second portion of a declaration of ownership. Also, it refers to the administration of the syndicate of ownership. When do we convene annual general meeting? How do we send a notice calling the meeting? Who can be a member of the board of directors? Who can be an officer of the general meeting? all of those topics that I will bring forth later on regarding, well, some explanation regarding those issues or with regarding those aspects a little bit later on tonight. So this is the second section of the Declaration of Ownership, and the last one, which is description of the fraction. Basically, it's like baptizing each and every lot numbers of the Declaration of Ownership. So, for example, if we look here, we see private portion, and then we will have all the lot numbers of the private portion, either parking spaces, either, for example, here it's housing units. And at the end of it, we will have one or, for example, lockers also. There's some lockers. And then we have we'll have the common portion of the building. Like I said, normally there's only one or two lot numbers. In this case, there's only one. I'm not going to get into the details of Declaration of Ownership before or previously to 1994, but like I would say, it's a little bit like a Cracker Jack box. Everything was mixed and there was no three parts of a Declaration of Ownership. But today, since 1994, everything is within a shape and form that is mandatory. Now, when we talk about the Syndicate of Ownership, it works, like I said, through its organs. There are two organs in a Syndicate of Ownership. The first one, the Board of Directors. The second one, the General Meeting of the Owners. We'll see this in a different shape. So when we look at a Syndicate of Ownership, it's constituted of two decisional organs, the Board of Directors and the Annual General Meeting. The Annual General Meeting, sometimes there could be some special meetings. Anyway, it's the general meetings of all the owners. So at General Meeting of the Owners, there are officers, a president, a vice president, and a secretary. The president of the general meeting will chair the meeting, will make sure that there's a decorum, will make sure if a vote passed, if the decision was made or not, will be there to give the right to speak to the owners who are present or represented, will compute, will revise the minutes of the general meeting, and later on afterwards, will make sure that the minutes are filed within the registry of a Syndicate of Ownership. On the other side, we have the day-to-day management, the board of directors of the Syndicate of Ownership. Normally, it's few people. It's 3, 5, 7, sometimes only one member who will be on the board of directors. The people who are on the board of directors are different people than the officers of the general meeting. Sometimes there's confusion, or sometimes a person or some of the people might chair on both sides, but some Declaration of Ownership do not allow it. Anyway, so if you're on the board of directors, you're called administrators. I would say that some, a lot of Syndicate of Ownership, the people on the board, they like to give themselves title. President, vice president, secretary, joker, vice president, treasurer. It doesn't change at the end of it, because when you're on the board of directors, you have normally one vote, and the decision of the board of directors are taken by a majority vote of the people who are on the board of directors. So if you're 5 people on the board of directors, decision requires 3 out of 5. If somebody leaves the board of directors, well, it's 3 out of 4. If there's only 3 people left on the board, well, then it's 3 out of 3. And if there's only 2 people out of those 5 at the beginning on the board of directors, you cannot make decision no more. You need to call a general meeting in order to have new people elected to be on the board of directors. So basically, when you're board of directors and you chair and you are a president, what are you the president of? You are not the president of the Syndicate of Ownership. You are the president of the board of directors. What does the president of the board of directors do? Well, he chairs the meetings of the board of directors. What does the secretary? Well, he's going to take the minutes of the meeting of the board of directors. What does the treasurer? Well, he's going to bring forth the information regarding the financial statements and regarding checks to be signed and those sorts of tasks. But it's not because you're the president of the board of directors that you have more powers than the other members of the board of directors. Actually, it's much more a duty that you have on your own. You're going to be chairing the meetings of the board of directors, and if you're not there, the vice president will do so. Well, if you're on the other side, and then we talk about the general meeting of the corners, there are officers, and the officers strictly needs to have at least two, president and secretary. And in some big cornership, you will have vice president. If the president is not there that night, or if he's sick, or if he's got to speak as a corner, or that he's in conflict of interest, then he will leave his chair, and the vice president will take over during that time. 1039 of the Civil Code of Quebec. Now we're into the responsibility of a syndicate of ownership. That article is, like I put there, the cornerstone article of divided ownership. It summarizes very well what is the object of a syndicate of ownership. So I'm going to read it to you. Upon the publication of a declaration of ownership, the owners as a body constitute a legal person. What does it mean? It's a legal body. Just like, for example, McDonald's is a legal body. You will have a board of directors, and you will have a meeting of the shareholders of McDonald's. Same thing for Burger King, whatever. Maybe I'm hungry or something. That's why I refer to food. Anyway, so the object of which are the preservation of the immovable. So to make sure that the building stay always as is, it does not deteriorate. The maintenance and the administration of the common portion of the building. And you see here, it refers to common portion. When we refer to common portion, it includes common portion for restricted use, but it does not have the administration of the private portion of the building. And therefore, if you have a daycare person working in your private portion, it does not belong to the syndicate of ownership to deal with this. Everything that is inside your private portion, as long as it's within the boundaries of your private portion, syndicate of ownership, except for the insurance, and we'll see this later on, doesn't have the administration. So it's also there for protection of the right pertinent to the movable or the ownership, as well as all business of the common interest. We'll see this into further detail afterwards. The legal person, and that's something that was added January 10th, 2020. It's a little bit mentioned, a little addition. It says the legal person must in particular see to it that the work necessary for the preservation and maintenance of the immovable is carried out. The legal person is called a syndicate. So manage common portion and all operation of common interest. Another task, to keep a register of the syndicate of ownership. What? Why? When you're in the ownership, owners might have some needs to consult some documents of the syndicate of ownership, the legal body. Well, if we look at 1070, it will explain what are documents that are at the disposal of owners. So let me read it very fast. Among the registers of the ownership, because there's more than one now, the syndicate keeps at the disposal of the owners a register containing the name and mailing address of each owner. Now, name and mailing address, not the email address, not the phone number. It might happen that in your ownership, the board of directors have this information, but it's not part of the register of the syndicate of ownership. Why? Because the legislator, I guess, thought that all this information should not be sent out, because if not, all the owners would draft emails to all the owners, or some owners might decide to call you, or so basically only name and mailing address to limit the access. The register may also contain other personal information concerning a owner or another occupant of the immovable if he expressly consents to it. In addition, the register contains the minute of the meetings of the owners, the annual general meeting or the special meetings, and of the board of directors, the second decisional organ. The resolution in writing, the bylaws of the immovable, the second section we saw in the declaration of ownership, and any amendment to them, and the financial statements of the syndicate of ownership. The register also contains the declaration of ownership. Well, amendment to the Declaration of Ownership and bylaws are part of the Declaration of Ownership. Oh, by the way, a lot of people are saying, bylaws, they're not the Declaration of Ownership. Yes, they are. It's a part of the Declaration of Ownership. Also, the copies of contracts to which the syndicate is a party, a copy of the cadastral plan, the plans and specification and location certificates for the building, if they are available. The maintenance log, if you are doing in your ownership maintenance, and it's best practice to have such a document, maintenance log of what needs to be done on the building at what time and when things needs to be changed for the elevator, for the ventilation system, etc. The contingency fund, which I will describe a little bit later on, and all other documents, information relating to the immovable and the syndicate or prescribed by government regulation. Example of other documents, we can think about expert reports. We could think also about quotes, about tenders, but documents that are not within the register. For example, we have bank statements, checks, interim financial statements. Those documents are not for the owners to see. Of course, if you have a lawyer, if there's lawyer exchange with the Syndicate of Ownership, their invoice, the invoice of the Syndicate of Ownership with their favorite lawyer are not within the register to protect confidentiality between the client and lawyer. Finally, the register contains a description of the private portion that is sufficiently precise to allow any improvement made by the owners to be identified. Basically, it's a new addition to the law, the fact to describe the private portion of the building. It's to help out the owners and the insurance company to make sure that they're covering what they're supposed to cover. I will explain a little bit more about this later on. A third task or obligation of a syndicate of ownership is to prepare and consult the owners on budget for the financial year of a syndicate of ownership. The way it works, you need with the notice calling a general meeting to send a budget to the owners with the agenda and everything, and you need to consult the owners on that budget. After which the board of directors, which will be elected direct that night, will, after having listened to the owners, fix the budget and then send to the owners the notice about what is their share of the budget for the next year. Now, managing the budget also means that there's another section that needs to be dealt with, which is the contingency fund. The contingency fund of a syndicate of ownership is there to put in a bank account money for major repair or replacement of the common portion of the building. We can see here, this is 1072 of the Civil Code of Quebec, that you need to put at least 5% of the contribution to the common expenses, so the financial administration part of the budget, that every year for the day-to-day care of the building. So you need to add up, for example, let's say you have a budget of $100,000. You need to add up at least 5% of this amount to the $100,000 to put in the contingency fund for that whenever you need to do a major repair or replacement of the common portion of the building, to have the money available. This 1072.1 of the Civil Code is an addition that was put by a legislator just about a year and a half ago. It's just to clarify that whenever you do a special assessment, well, also you need to do the same mechanism. So you need to call a general meeting, you need to consult the owners, after which the board of directors will fix the expense to be paid by each and every owner. Now, I wanted to show you a different way to see what is a contingency fund. And I thought maybe if I do a little drawing, it will help out to understand what is the contingency fund and how do you put money in the contingency fund. So basically, this is a line of time. 0 is today, 3 is 3 years, 5 is 5 years, 10 is 10 years, 15 is 15 years from now. Let's say that in 3 years from now, we need to replace the tapestry of the corridor. In 5 years, we need to change the window balconies. In 10 years, the roof. And in 15 years, the building envelope. And let's put some amounts. Like here, there's 5K, 15K, 45K, and 90K. Well, you take all of those amounts and using a discount factor of interest, you're going to bring them all to today. And if you have less than zero in the contingency fund with all the amount that are paying through the time of the corners, it means you need to invest more than 5%. And if it's, it means that it means that the opposite. It means that you don't need to put money in the contingency fund, so that therefore you can put at least 5%. But if when you put everything to today, the amount is greater than zero in terms of dollars, it means that you don't have sufficient amount of money, so therefore you will need to probably increase the amount to be paid every year in the contingency fund, so that whenever it will be time in, for example, 3 years to replace the tapestry, that the amount will be available, but also that a certain amount will be kept through the time, so that whenever you need to change the balcony or do major repair to the roof, that you still have enough money to pay for each and every major repair or replacement of the common portion of the building. Another job of the Syndicate of Ownership is to collect the condo fees of co-owners. Now, how do we pay as co-owner the condo fees? Basically, it's according to our share of the building. So I showed you earlier today the template of a declaration of ownership, Article 25. You saw that there was a table with all the lot numbers and with at the side a certain percentage on 100. Well, that's your share of the condo fees that you need to pay through all the checks that you're going to be sending to the Syndicate of Ownership, 12 checks, or by automatical deposit or other ways. So basically, you pay according to relative value of your fraction. So basically, if there is 10 private portion in a Syndicate of Ownership in the building, not everyone pays the same amount. It really depends on many factors, and those factors will decide what is your share of the building, and you pay according to that share. Recover unpaid common charges. Yes, not everyone is paying on time their condo fees. So therefore, there's some means that were given by the legislator to a Syndicate of Ownership in order to force the owners to abide, or to give some tools for a Syndicate of Ownership in order to make sure that he's able to get back the condo fees if a owner doesn't pay on time, or if he's very late. One of those tools is illegal hypothec. So if a owner is late for more than 30 days in the payment of his condo fees, the Syndicate of Ownership can go see his favorite lawyer, for example, and tell him, hey, I need to put a legal hypothec on the unit of a owner because he's not paying his condo fees. The legal hypothec, it's a charge on the property of the owner. So it's like a lien, if you want. So it's something that you put, just like a mortgage for a bank, it will put a lien on the property. So it's the same thing, and it stays there. It protects the amount, and making sure that if the owner doesn't pay, that there's a certain guarantee for the Syndicate of Ownership that they will be later on, or in the meantime, is going to court to collect the money, certain protection. When we talk about the declaration of ownership, we need to understand that if you buy in a ownership, according to your deed of sale, but also according to the law, you need to abide by the declaration of ownership. There are also some civil code of Quebec articles that refers to the other people. The lessees, the occupant are also abide, and they need to follow by the terms of the declaration of ownership. So if we look at the 1057 of the Civil Code of Quebec, it says that the bylaws of the Immovable, second section of the declaration of ownership, may be set up against the lessee or occupant of a private portion upon his being given a copy of the bylaws or the amendment to them by the owner, or if not by him, by the syndicate. Just so you know, landlords and tenants, If you're a landlord, at the time of signature, or at least before signing the lease with the tenant, you need to provide him a copy of the bylaws of the immovable. It's another article of the Civil Code of Quebec within the section of the lease, but it's your duty and it's part of the law for you to provide to your tenant a copy of the bylaws of the immovable so that it's enforceable against him. As for the corners, 1062, the Declaration of Ownership binds the corners, their successors, and the persons whom sign it and produce its effect towards them from the time of registration. So corners, it's directly both by the law, but also when you sign and you buy a property in a condo, you will normally have a clause in your deed of purchase that you need and you're going to abide to respect the terms of the Declaration of Ownership. Another obligation of a syndicate of ownership, it's to take out insurance. A syndicate of ownership, not everyone knows that a syndicate of ownership needs to insure the whole building, including the private portion of the corners, except the improvement made by a corner to his private portion. What does it mean? It means that to avoid having Swiss cheese co-owners, if there's a major damage, well, the legislature decided that the syndicate of ownership needs to insure the full building, including the private portion of the building, except the improvements. What are the improvements? The improvements, for example, let's say you have carpet in your private portion, in your dwelling unit, and that you decide after authorization of the board of directors, you need to change this for hardwood floor. You understand it's an improvement. So therefore, from that moment on, your own insurance company for your civil liability, but also for your belongings, will also need to cover and to pay for any extras that you might decide to change in your private portion. Another thing that is important to know is that the syndicate of ownership needs to insure the full building for a replacement cost of the immovable. So basically, it's like if the building, for a reason or another, is destroyed by a fire, then the amount of insurance needs to cover to rebuild the building as new. Another thing that we need to know about insurance of a syndicate of ownership, apart from covering the part of the building that needs to be covered, it also needs to cover the civil liability of the people on the board of directors. Very soon, they will need also to insure other people, like the officers of the general meeting, like the manager will need to be insured. So a lot of other people also need to be insured, but so the syndicate of ownership needs to have insurance for those things. Now, these are the duties in general. Now, if we split this into who's supposed to take care of those things, we will discuss at this time the two decisional organs of a syndicate of ownership, and we will start by the annual general meeting of the corners. General meeting of the corners. Every year, at least, you will have a meeting of all the corners where the corners will gather in one room, or actually with COVID online with one of those systems that allows you to be able to be at the same time together and to hear everyone. So basically, you will have every year at least a general meeting of the corners. And at that time, the people will come in the room and they will sign a document, which is a present sheet, and then they will sit in the room and then they will listen to somebody in the front and go through the agenda, and sometimes they will be requested to vote. Now, in order to have a general meeting of the corners legally, you need to have quorum. A quorum at a general meeting of the corners require at least 50% plus one of the voting rights of all the corners present or represented. If you don't have this majority, then you need to adjourn. But the good thing is that whenever you're going to reconvene or send a new notice for the general meeting, 3/4 of the members present or represented in the room will constitute quorum. I don't want to get into detail, but just to let you know that it's not that difficult if you don't have an adjournment, if you need to have an adjournment because there's not a lot of people, it's actually easier. However, some of the decision will be more difficult to obtain, but I'm not going to get into those details tonight. Like I said, tonight it's a crash course. I'm trying to give you as much information as possible, but at the same time, all of this cannot be seen in one night, actually. So I'm trying to focus on the most important things I would like to share with you in order for you to have at least a view about what is divided ownership in Quebec. Okay, yes, something that we need to know. You need to convene and have a general meeting of the owners every year. According to the law, you need to have this general meeting at least or within 6 months after the close of the financial period. However, a lot of declaration of ownership will reduce this to 3 months after the close of the financial period. Of course, during a general meeting, you don't need to assist. You can also have somebody by way of proxy to represent you to vote on your behalf. If there's more than one corner for one fraction of ownership, you're going to vote according to your share. Normally, let's say that me and my wife, we are the owner of a fraction of ownership. We're going to vote, and let's say that our share is 5%. So we're going to vote 2.5% each. But if one of us is not there, there's a presumption, and which is the last point or bullet in this slide, that allows me or my wife to vote for the other if the other one is not there. However, some people, when they buy, there's two co-owners of one fraction of ownership. It's not necessarily 50-50. You will see sometimes it's 75-20. So if it's 75-25, then they're going to vote according to what is in their deed of purchase. When we call an annual general meeting of the owners, we need to provide to the owner a notice calling the general meeting. And this shall be accompanied in addition to the balance sheet by the income statement. Basically, it's the financial statement of a syndicate of ownership, the budget forecast for the next year, and any draft amendment to the declaration of ownership, plus a note on the essential terms and condition of any proposed contract or planned work. What is that? A note on the essential terms and condition. Basically, it's quotes. If you intend to have something done during the year, you need to send with the notice calling the meeting the quotes, or at least the essential terms. What is the price? What will be done? So that the owners during the general meeting can be at least able to discuss the issues or the things or the tasks that might be done during the next year following the consultation on the budget. So when we call a general meeting, this is a template of a notice calling a meeting. So a syndicate of ownership to all co-owners. Please take note that on such date, time, and place, we will have a general meeting. That if you want to add a point on the agenda, you can do so according to 1088 of the Civil Code of Quebec, which states that within 5 days of receiving the notice calling the meeting, you have the right as a co-owner to add a question to be on the agenda for the general meeting of the co-owners. And also proxy, of course, you can give a proxy to anyone you wish to represent you should you not be available. It can be people on the board of directors, it can be another co-owner, it can also be somebody else. It can be your favorite lawyer or notary, or it can be also your friend because you're not there and they're able to represent you. Just so you know, some declaration of ownership states that the proxy needs to be given to the board of directors at least 48 hours before the general meeting. But just wanted to let you know, legally, it doesn't work. It's illegal. Even if I arrive at the general meeting the same, like 10 minutes before the general meeting with my proxy, I shall be able to sit in the room and to vote on behalf of the person I represent. Now, this is a template of a normal agenda that we see during an annual general meeting of the Corners. And basically, it's usual agenda of a general meeting of the Corners. So basically, at the beginning, we will verify and make sure there's quorum. Like I said, a quorum constitutes at least 50+1 share of all the voting rights of all the Corners in order to declare the general meeting open. At the beginning, the first thing we will do during a general meeting is to select and elect a president and a secretary of the general meeting. Like I said, the president will chair the general meeting of the Corners, the secretary will take notes, and later on, after the general meeting, they will verify the minutes of the general meeting, and they will give it back to the board of directors, who will deposit the minutes of the general meeting within the register of the Syndicate of Ownership. Point 3, reading of the agenda. In some Syndicate of Ownership, they have the tendency to put adoption of the agenda. Well, so in a general meeting of the Corners, you don't adopt the agenda because 2 articles, 348 of the Civil Code of Quebec and 1088 of the Civil Code of Quebec, which states that if a Corner wants to add up a question to the agenda, it needs to submit his question to the board of directors within 5 days of receipt of the notice calling the meeting. And 348 that states that no question can be discussed or decision made if not all the Corners are present or and agree or consent to adding up a new point on the agenda. Why? It's to protect the Corners who decided not to be present at the meeting. I received my notice of convening the meeting. I see that there's a lot of points, but nothing interesting for me to be there. I decided not to be there. But whoa, I learned afterwards that new decisions were made and I would have liked to be there. It's for their protection. That's why we cannot add new question on the agenda, except if everyone is there and everyone agrees. This being set aside, and we see this at point 10 of the template of an agenda, it doesn't mean that Corners do not have the right to speak on other topics. If it's not a vote and it's a question of general interest for the Corners, in some Syndicate of Ownership, they will put it varia or good and welfare within the agenda. If you have something to discuss, the garbage are not well maintained, there's some smell in some part of the building, or there's an issue, people throwing cigarettes from the roof or whatever. If there's something that you would like to share with the Corners, of course, during the annual general meeting, you have the right to discuss those issues. However, no votes will be able to be taken regarding those issues. Normally, after you read the agenda, well, normally it's going to be the president who will read the agenda. There will be the board of directors report. So they will explain to the Corners what happened during the year. They will let them know what are their priorities, what they were able to do, what could not be done, what is in progress, in order for the Corners to have a little visibility on what's going on in their Cornership. So traditionally, afterwards, they will answer the question of the Corners, and there won't be any vote following following the question being answered, and we will afterwards move on to the next point. If there's modification to the bylaws, it should accompany the notice calling the meeting. So the Corners during the meeting will discuss if there's a bylaw submitted to a vote, the content of it, and then they will move to a vote. And if they get the absolute majority, then it will change the bylaw of the immovable. If it does not obtain the proper majority, then it will be rejected, and there won't be any decision on it. Normally afterwards, in a typical general meeting, we will have a presentation for consultation of the Corners on the budget. The budget, for example, here for 2021, 2022, it's a vote. This is best practice. This is not necessarily mandatory, but this is best practice to proceed to a vote, but it's a non-binding vote. Like we saw earlier when we talked about the 1072 of the Civil Code of Quebec, annually, the board of directors fix after consultation of the corners, the budget. Therefore, who's got the power to fix the budget? The board of directors, but they need at least before to consult the corners. And what's the best way to consult the corners on a budget? By a vote. However, it's not because the corner, no, let me put it another way. Even if the corners vote against the budget, if they elect the same people in the board of directors, those people will fix the budget according to what they present, but taking into consideration that if they think that that's the thing to do, if they believe that after listening to the corners there should be some changes, they will fix the budget differently depending on what they heard during that night. If it's other people who are on the board of directors, they might decide to change the budget, and but it's their choice. Just like, for example, when you elect somebody at the city as a mayor, they're gonna make promises during the campaign, then you vote for them, and afterwards, well, they can decide to increase the municipal tax, and that's the way it is. They have the power. The board of directors got the power over the budget. Why? Because they have big responsibility. Therefore, be able to accomplish those responsibility, they need to have the money in order to proceed and to exercise their obligation. If not, there would be an issue, because corners would not increase the budget. There are things to be done, so the corners would be putting at stake, and the corners would be the board of directors would have their liability on the line because they don't have the money to do what they're supposed to do. So that's why the legislator thought and think that it was the best thing to do to make sure that the budget is fixed by the board of directors and not by the AGM. This being said, if ever there is special assessment, same thing, you need to proceed to a vote, but it's a consultation vote. Let's say, for example, like here, that there's a legal action by a corner against the syndicate of ownership, or the syndicate against the developer, or whatever. You might want to have the money right away. So what you'll do is you'll do a special assessment to make sure that the money is collected very fast in order to proceed to what needs to be done. So it's same thing for if you have a major work to be performed in the building, you don't have enough money, you will call for a special assessment in order to make sure that you have the money right now and not wait 12 months to have the full amount of money, or to have sufficient liquidity in order to proceed. Those points being discussed, normally close to the end of the meeting, you will have the election of the members of the board of directors. The way it works, if you want to be on the board of directors, you need to obtain a majority vote of all the corners present or represented in favor of you being on the board of directors. You cannot say we are 3, and if you vote for us, vote just 1, and if you don't vote for us, well, vote for the other team. No, it's an individual task and duty to be on the board of directors, and individually, each member of the board needs to be elected one by one. Should, for a reason or another, during the general meeting, we don't have quorum no more, and that a corners request to make sure and see and count if we still have the quorum. Should we not have the quorum, we need to adjourn, and then later on convene a new general meeting in order to finish with the points on the agenda. This is just a little example of what is a proxy. It can be very simple. It needs to be in writing. That's mainly one of the obligations that you have, and to provide it to the general meeting with the signature of the corner, explaining like this, for example, who's going to represent me, the name. It cannot be, I understand corner, designate the syndicate of ownership hereby to represent me. It needs to be somebody who is identified with the name of that person, or we can see who is the person who's receiving the proxy. And if you have a proxy from someone, it's your proxy. You cannot say, well, I'm not gonna go to the general meeting and I give this proxy to somebody else. You receive a proxy, it's individual responsibility. So you cannot share this with somebody else and decide not to go and to give it to somebody else. It belongs to the corner to therefore give a proxy to somebody else, and you don't have this this choice of re-giving the proxy to somebody else. This is an example of note on the essential terms and condition. We don't see this very often. Normally, what we'll see is attached with the notice at the end of it, a bunch of quotes that the Syndicate of Ownership wants to submit to the corners for them to discuss later on during the night. But like I said, it does not belong to the general meeting to vote on should we choose this person to do such work on the building. This is within the power of the general meeting of the board of directors of the Syndicate of Ownership. Of course, when we enter into the room, if we are in presential of a general meeting of the corners, we will have an attendance sheet. You arrive at the entrance of the door of the general meeting, and normally there's going to be a table, and at that table there's going to be somebody there ask you to sign, saying that you're there for your fraction of ownership, and then you'll sit in the room and wait for your turn. And with this attendance sheet, the quorum will be able to be established to make sure that we have the majority vote in order to proceed with the general meeting. I wanted to do a little table regarding how to compute the vote. So, for example, here, let's say that Bob, George, Alain, Suzanne, Didier, and Robert are present by way or present or represented by way of proxy. We have quorum 55%. So it's not how many people are in the room. It's not we have 5 corners out of 10. It's in terms of voting rights. Some corners have greater amounts. For example, here, Bob has 5%, but Alain's got 15%. Why? I don't know. Maybe Alain lives in the penthouse while Bob's lives on the main floor. So basically, if you get 51% of the shares present or represented, you can open the general meeting. Decision at the general meeting of the corners requires absolute majority. And this is for all the decision that needs to be taken during the general meeting. Example, officers and administrators. It's not like a federal or provincial or municipal election. It's not the one with the greatest percentage of vote who will be elected on the board of directors. You need to obtain absolute majority. So absolute majority versus simple majority. When we vote to elect people for the government, Canada, Quebec, or municipal, it's simple majority. With 33%, you can have a chair at the parliament, but with 33%, you cannot chair on the board of directors and you cannot be an officer. Same thing for modification to the bylaw, you need absolute majority, which means majority of all the voting rights of the corners present or represented. However, to protect the minority in a syndicate of ownership, the legislator decided to increase the degree of voting rights available and required in order to make some decision. For example, then this is 1097 of the Civil Code of Quebec. You need 3/4, 75% of all the corners present or represented during the general meeting in order to take such of those decisions. That we'll see 1, 2, 3, 4, 5. Just to let you know, 1097 before, it was a greater majority. It was majority of the corners representing 75% of all the voting rights of all the corners. But since January 10th, 2020, it was reduced to only 3/4 of the votes of the corners present or represented. For what type of decision? Acts of acquisition and alienation of immovable. The Syndicate of Ownership wants to buy a piece of land on the other side of the road in order to put, I don't know, a swimming pool. Well, you will need to obtain that majority. If the Syndicate of Ownership wants to do work for alteration, improvement of the common portion, he will also need to go into a general meeting and to obtain that majority. What are improvement or alteration work? Basically, if you want to change or improve the quality of the material of some common portion of the building, then therefore this article will apply. For example, let's say that you have a corridor and that the corridor is made out of carpet and you want to put, I don't know, a nice ceramic, or you want to put floor of hardwood floor of great quality. You do understand that you're not replacing by same. You're replacing by something different, improving. Therefore, that's why if the corners in a drum meeting, if more than 25% of all the corners present or represented disagree, you won't be able to do such a thing. However, of course, if it's due to an improvement of a technological improvement, it's not considered to be improvement, a work of improvement in your building. For example, let's say you have windows, and the windows installed at the beginning of the cornership do not exist no more, and that there's nothing exactly similar, but that there's something today available, but that it has better quality, then therefore it's just technological improvement and will not be considered to be improvement of the common portion of the building. Act of great. Amendment to the act constituting the cornership or of description of the fraction of cornership. Basically, it's the first and third section of the declaration of cornership. Therefore, if you want to change those sections, you need that majority. And finally, the new one, description of the private portion. Every syndicate of ownership had before June 13, 2020 to, by the board of directors at first, prepare a description sufficiently a sufficient description of the private portion in order for that the syndicate of ownership, the corners and the insurance to know what are the improvement in your declaration of ownership and your in the private portion of the building, and submit this to the vote of a general meeting of the corners in order to become the description of the private portion. So if you want to change it later on, that's the way to proceed. 1098 of the Civil Code, just so you know, it's a greater majority. If you want to change the destination of the immovable, I'll not get into the detail tonight, but just to let you know that, for example, if you have building with janitor living on site and you want to get rid of the janitor and have an external firm to replace the janitor and to sell the place where the janitor is living in the building, you might affect the destination of the immovable. So destination of the immovable is not only commercial versus residential. It's way more complicated than that. If you want to learn more about it, you can, for example, get into the courses I give in fall, and we'll get into all of those things in more details. Oh, in 1102, of course, let's say you're a small cornership and that there's 4 corners, and that you would like that everybody pays 25%, and that previously was not those amounts. You cannot force one of the corner to decrease or increase his share of the condo fees without his consent. Same thing for destination of his private portion. Of course, if a decision was taken by the general meeting and it was taken with the intent to injure the corners or in contempt of their rights, you can, as a corner, decide to appeal to the court. You need to do so within 90 days, which means you need to file your legal action within 90 days, not sending a demand letter. File within 90 days. And if you don't, then therefore the decision will be solid, and you won't be able to challenge it later on. Why? It's to make sure in a syndicate of ownership that if a decision is taken, that there's no legal action taken, let's say 2 years and something afterwards regarding such decision. So therefore, you need to act fast. Let's talk about the board of directors, the second decisional organ. The mission of the board of directors. The board of directors needs to make the decision and base the decision in the common interest of the corners, of the collectivity of the corners. It's there to ensure the day-to-day administration of the Syndicate of Ownership. Normally, in large Syndicate of Ownership, they will at least have meetings of the board of directors every month, and they will have most of the time a management company to assist them to manage the building of the corners. As I said, I said this also, the appointment of a management position, president, treasurer, secretary on the board of directors, it's not mandatory. Being directors, if you're 5, you can all be directors. Like I said, anyway, being the president of the board of directors, it's just, it only means that you're going to be the one chairing the meeting of the board of directors. It doesn't give you superpowers to make decision on your own and to decide whatever direction the Syndicate of Ownership will make. It does not mean that. Duties of the board of directors. As members of the board of directors, you need to act with prudence and diligence. You need to be loyal with honesty towards the Syndicate of Ownership and in its best interest. If you are on the board of directors, you cannot confuse your money with the money of the Syndicate of Ownership. You cannot borrow money from the Syndicate of Ownership. You're not supposed to use the tools of the Syndicate of Ownership for your own. And of course, you cannot be in a situation of conflict of interest with a Syndicate of Ownership. For example, if you're the shareholder of a company and you want the syndicate to give a contract to that company that you're a shareholder, you're in conflict of interest. What you will need to do is declare that you're in conflict of interest, get rid of move out of the room, let the other people on the board of directors make the decision, and you shouldn't take part either discussion nor to the decision. If you don't do that, you might be your liability might be at stake. A lot of members of the board ask us this question: how do we do if owners do not respect the declaration of ownership? And I tend to tell them, well, the best move you should do at the beginning is probably to put teeth to your declaration of ownership, which means modify the bylaw of the immovable. If it's regarding owners not paying their condo fees, you can increase the interest rate. Some of old declaration of ownership will put bank rate plus 3% per month, or very difficult to compute. I most of the time suggest put something like 24% or 28% per year. It's correct. I mean, you can put a greater amount to make sure that the owners, and they're very rational owners, if they have the choice between paying their credit card and paying their condo fees, if the interest rate of the Syndicate of Ownership is not charged by the Syndicate of Ownership or too low, the owner will rationally decide to pay their credit cards because they know that at the end of it, it's in their best interest. If it doesn't work, you can also put penal clauses. Since January 10th, 2020, if you want to change the declaration of ownership to put penal clauses, you need to do so by changing the act constituting the ownership. It needs to be in minutes. It needs to be notarized. It needs to be published at the land registry office. And you need to obtain the majority of 1097 that we saw earlier, which is 3/4 of the owners present or represented during a general meeting. Just like the annual general meeting, you can contest a decision of the board of directors. Same thing, more or less the same article and the same delay. You have 90 days after the decision of the board of directors. Of course, there's other articles applicable regarding the board of directors. Final point I wanted to express and discuss a little bit about tonight is Syndicates Manager. So when you're a Syndicate of Ownership and you're on the board of directors, most of the time you're not paid to be on the board of directors, but it takes a lot of energy, but it takes a lot of time. So what are a lot of Syndicate of Ownership doing? They hire a management firm, a professional external firm, to help them and to assist them with their duties as being on the board of directors. However, if you're a management firm, you're not there to make the decision for the board of directors. You're there to assist them. As members of the board of directors, you cannot delegate your decision to the manager. You will still have the decision-making power, but they will be there to assist. They will go for the quotes for you. They will prepare interim financial statements. They will go to the corners and send them correspondences to make sure that they pay the condo fees on time. They will be there also to assist you regarding whenever there's work that needs to be performed in the building, to be there on site, to assist the professional people who will need to do some work on the building. They will assist the general meeting. There will be most of the time they will be secretary of those general meetings. They will assist the board of directors, prepare the minutes, etc., etc., etc. The manager is an agent of the board of directors. It's not the people of the board of directors, but they have similar obligation, like we can see from this slide. So they need to comply by the obligation imposed on them by the law, by the constituting act of the Syndicate of Ownership. Again, just like the members of the board, they need to act honestly, faithfully, in the best interest of the Syndicate of Ownership. Just like the members of the board of directors, they cannot exercise their power in their own interest. They need to do it in the interest of the Syndicate of Ownership. And being a service provider, they also are bound to act in accordance with usage and good practice, and where applicable, to ensure that the work carried out or service supply is in conformity with the contract. And basically, I spoke very fast. I wanted to tell you a lot and as much as possible about condo law. I'm passionate about it, but I wanted to give as much stuff as possible. I know I speak fast. Imagine when I read. Anyway, I just wanted to provide you with a little bit of my spirit about condo law, and just a little teaser about the class I'm giving every fall and every winter for McGill.
Thank you very much, Maitre Fissé. That was a very informative presentation. I know that our listeners have been writing in the chat so much they appreciate it, and also there's lots of questions, so we're going to get started. I'm just going to say that there's a lot of questions. I don't think we'll get to all of them, but I have been taking note of all of them, and we will try to answer to them. I will send them to you, Maitre Fissé, and we'll try to get through them as best we can. So there's a couple of questions that relate to COVID, so I might just start with those because it's a topical and question. So here we have one question that says, what replaces an attendance sheet during times like COVID when meetings are done via Zoom? Is a list of people present in the meeting minutes sufficient?
There are portals that are used by Syndicate of Ownership in order to proceed with video conference to the general meeting. Those portals, they're very well made, and normally basically the way it works is that there's the portal manager will obtain from the Syndicate of Ownership the declaration of ownership, so therefore he will be able to know what are the relative value of each and every fraction. So therefore, afterwards, a link will be sent to each and every corners. Whenever they connect, then they will be added up to the quorum. So therefore, at the beginning of the meeting, we know exactly what is the quorum because the system computes it on its own. And then afterwards, when the votes are taken, you press a little button, yes or no, and therefore the system on its own computes everything. So the person chairing the meeting will see live what is the result and being able to share it with the corners. I don't know if I answered the question, but of course you don't sign, therefore, present sheet. It's much more by you clicking in, just like whenever we connect, for example, now on Zoom. The fact that you're in, then it's computed and your voting rights are put with the quorum, and afterwards when you vote according to relative value.
Thank you. So one last COVID question, and it's related to the vaccine passports, which is just the hot topic now. Can a syndicate choose to have a person in AGM this year, despite the introduction of vaccine passport by the Quebec government? What are the rights of the co-owners who are not fully vaccinated in such case?
Oh, my understanding from what the government announced is that it's not going to be applicable to private issues. A syndicate of ownership is a private thing. It's an association of owners within a legal body. It's not a public place either. Well, except for some exception where buildings where it's commercial or some part of commercial, maybe some parts of the building will be public. But as for the rest, it's a private building, and therefore it's not supposed to be applicable. Those restrictions. But at this time we don't know it. But from what I understand, would be restaurant or gym or stuff like that, not applicable to a syndicate of ownership, and therefore I think the same should apply with the gym of a syndicate of ownership, or if there's a swimming pool, there should not be applicable. However, best practice in syndicate of ownership, it's to apply those rules within the ownership itself.
Okay, thank you very much. So we'll go now to the list of questions. So can you give us some details about the legal requirements for self-insurance fund? How much is the minimum to be kept there?
Self-insurance fund is not yet into force. It will come into force in 2022, if I recall correctly, in April. At that time, you will have 1 year to put in a self-insurance fund, at least 50% of the highest deductible of your insurance policy. So, for example, let's say that you're in a ownership with a lot of leakage, and let's say that your highest deductible is 100K. The first year you will need to put 50K, and the second year, so basically April 22 to April 22 to April 23, so it's 50K, and the next year 23, 24, the other half 50K within a self-insured fund. But also a sufficient amount to cover everything that is below the deductible, because since the last amendments to the Civil Code of Quebec, now it's the responsibility of the Syndicate of Ownership to do all works regarding common portion and private portion of the building, except for the improvement, either it to be below or higher than the deductible. So it's 100K plus, let's say that normally you have leakage or of minor issues of, let's say, 5K per year. So you will also need to put an additional 5K within the self-insurance fund. This being said, it's best practice to start now. A lot of management companies and a lot of syndicate of ownership are starting right now to contribute to that fund, but it's not mandatory yet.
Okay, thank you very much. We have another question. Is this a good moment to buy a property in Quebec?
That's a qualitative question. Is it a good time? You know, there's always pros and cons. Now the interest rates are still low, but the value of the property increase because the market is hot. Now, if you wait 3-4 years, maybe the market will be colder, but the interest rate will be higher. So basically, it really depends. It really depends. For example, if I sell my property right now, maybe I will get a good price for it, but I need to buy somewhere else to live. So basically, it's not exactly a win-win situation. So is it a good time to buy? I would say maybe 2 years ago was a good time to buy. Maybe not more today, maybe less today.
Okay, thank you very much. How do we remove the current syndicate if we're not happy with their work? Also, if we're having issues with the syndicate, who can we get help from or seek guidance from?
Okay, if you want to get rid of your syndicate, I believe it means if you want to get rid of the people on your board of directors. If you want to get rid of the people on the board of directors, you have two choices. Basically, you can wait for the next annual general meeting with the owners, and therefore at that time present yourself with a group of other people who would like to be on the board of directors. Campaign, make sure that you have a lot of proxies, knock on doors, just like federal election coming soon, and then therefore arriving there with all your proxies and having the majority and kick them out. Another option is to, if you represent more than 10% of all the voting rights of the co-owners, you can use an article of the Civil Code of Quebec that allows you to ask the board of directors to convene a general meeting of the co-owners. And for example, you can put on that agenda to increase the people on the board of directors. Let's say you have 3 people on the board of directors. You can ask to change the bylaws of the Immovable to increase the amount of people on the board of directors to 7. So if you put 7 people on the board of directors, then it's 4 against 3. So basically, whatever, if they decide to scream, at the end of it, you will have the majority and take over. And finally, the other option that is very rare, or very uncommon, it's to ask the co-owners to have the people on the board of directors to be destituted, but you need to have a fault, and it's a little bit like a trial. It's very uncommon that you're able to get into a situation where it's possible to do such a thing.
Thank you. So now we have a bit more practical question. If a condo developer makes changes to the unit and has not notified the buyer, even if there is a clause in the contract that there should be a written agreement from all parties for all changes, what are the legal recourses that the buyer can take against the developer?
It's always an individual issue. When you sign with a developer, you normally sign on his contract. It's not a template. All the contracts are not the same. So we need to look at the preliminary contract. We need to see if there's a loop or a way out. For example, did you receive the note that needs to accompany the affirmative note that needs to accompany the preliminary contract? Did he provide you with a copy of the draft of the Declaration of Ownership? Many things can be done. On this side, we need to read the declaration of, we need to read the preliminary contract or the promise to purchase, if you want. And sometime we're going to be able to find a loophole or a way to find a way for you to get rid of the sale or to negotiate with him. But if in writing clearly states that he needs to obtain your approval in order to change the description of your private portion, then he cannot do it on his own. Basically, you have 2 choices then. You can try to get rid of buying, or you can decide to buy under protest and then try to sue him later on to have a reduction of the selling price because what he promised to you did not accomplish.
Okay. How can you make your condo building complete non-smoking, including balconies?
Difficult. Smoking is still legal. You have the right to smoke in your private portion. Should you want to forbid smoking in a private portion, so in your dwelling unit, for example, you will probably affect what is called the destination of the immovable. The example I gave regarding the janitor that you would like to replace and put an external janitor, same thing should apply. You would need to go in a general meeting, get the proper majority, and then afterwards submit this to a vote, get the proper vote, which is 75% of all the co-owners of all the co-ownership, representing 90% of all the votes of all the co-owners of the co-ownership. Therefore, if there's more than 10% of absent during a general meeting, you will not be able to go ahead with this. But there's some things we can do in the bylaws or in the constituting act to accommodate or the co-owners and their needs. But to forbid, it's difficult task in a syndicate of ownership. You need to understand that the ownership is not a democracy. It's mostly there to protect the minority against the majority, but at the same time to provide enough room for the majority to decide regarding the direction of the building. But it's always individual rights versus collective rights. So it's not that easy. If somebody tells you you can forbid smoking, not that easy, not that easy. But if you get the proper majority, it's always possible. But just so you know, this is for co-owners. For tenants, if you're the landlord, you have the right to put that non-smoking in the unit. That's something different.
Okay, so I'm just keeping watch of the time. It's already 7 o'clock, but I'll take a few more questions. And we will get back to you with the numerous other questions that we have. So would the requirement of tenants, of co-owners, to have their own insurance be included in the declaration of a co-owner? If so, which section would this appear in?
Civil liability of the tenants can be either taken by the tenant or by the landlord. If you're the landlord, if you want to protect your property, you should insure the civil liability of your tenant. Now, if your tenant caused damages to the building, the insurance of the Syndicate of Ownership should cover. And also, according to 1074.1 of the Civil Code of Quebec, the insurance of the syndicate and the syndicate will not be able to go against the tenant except if the syndicate can prove a fault of the tenant of the owner, or if there's some specification and declaration of ownership to create a contractual fault for the tenant in such circumstances. If not, the syndicate of ownership will not be able to, for example, recuperate or ask for the tenants to pay for the deductible, pay for the damages. Now, this being set aside, in what section? There's already a section in the Constituting Act that refers to the insurance, and that's where all the stipulation regarding insurance are. Now, as for the question of the tenant to force him to take an insurance, we don't see this very often, and basically the owner of the dwelling, the landlord will make sure to insure him the risk and not the tenant. But you could put this in your lease as a stipulation if you're the landlord.
I'll take one more question here. Are the certificate of location also available at the land registry office?
Two things. Cadastral plan, it's the picture at the beginning of the co-ownership of the division between the common portion and the private portion of the building. The certificate of location is a picture in the time of the same legal situation, but including any encroachment to the common portion of the private portion. So if there's an encroachment, the certificate of location will show it. It will give you greater details sometime. And normally, if you want to sell your private portion of the building, you will need, and the notary will request from you to obtain a new certificate of location for your private portion. Now, this is for private portion. Now, as for the building in itself, we don't see this very often, that the Syndicate of Ownership obtains a certificate of location of the whole building because of the cost of it. You will normally not have this, but it happens that you will have this sometimes, but most of the time will be for the private portion of the ownership, not for the common portion of the building.
Okay, thank you very much. So, Maître Fisset, we have numerous questions. I don't know if you would be willing to stay for an extra 2-3 minutes. I can get through more. Otherwise, we can.
Yeah, I'm there.
You're okay. Okay. So, if the previous syndicate did not respect certain laws and regulation, can the syndicate be held responsible?
A syndicate of ownership is a legal body. If people on the board act wrongfully, the syndicate of ownership liability is at stake. The people on the board of directors are insured by the syndicate of ownership. So if the board of directors liability is at stake, the insurance of the syndicate of ownership should cover it. For exception, mean, criminal or fraud or stuff like that. But as for the rest, normally the insurance should cover, but it will not cover everything, of course. If the board of directors take decision of opportunity that was not the best decision, it's not covered by the insurance company. But if somebody on the board of directors, for a reason or another, does something or make a decision and it creates an omission, or it's a fault for the syndicate of ownership and somebody's suing the syndicate of ownership, the insurance company will cover such a thing. Now, as the syndicate of ownership and the people living in the syndicate of ownership, if you're on the new board of directors and you believe that the past board of directors did something wrongfully, you can, with the use of the syndicate of ownership, decide to sue those people of the board of directors for what they did. So therefore, it's not because you're on the board of directors that you're protected. The insurance company might cover, but if you take over the syndicate of ownership and you want to sue the ex-members of the board because they did not abide by their responsibility, therefore you can use the vehicle of the syndicate of ownership to sue them in order for them to be liable for what they did.
Okay, thank you. The next question is the board of directors allowed to request co-owners' emails through the management company to send an email to all co-owners?
Can they? Two things. First of all, 37 of the Civil Code of Quebec. If you want to constitute and get information from someone, you need to have a reasonable reason. That's the first thing that you need to take into balance. Second thing is, should they want to obtain your email, they need to put this within a bylaw. They need to amend the declaration of ownership in order to force you to provide them with such information. Now, this being said, it will not and it shall not be included in the registry of the syndicate of ownership, like I said earlier. Now, this being aside also, they need to find a way to make sure that they're not abusing of their rights. Normally, what we'll do is either you will provide your email address, or, for example, if it's to send you the notice convening the meeting, otherwise we will send you a copy by mail. Most of the time it's to facilitate the communication. So therefore, if there's no modification to the declaration of ownership to force you to provide your email address, you don't have any obligation to abide and provide your email address.
Thank you. A lot of different articles are saying that 5% for contingency fund is not enough and is the reason why so many co-ownerships are broke. What do you recommend?
Way back when I was managing buildings, and that's 2001, 2002, I was at that time having both hats. I was a lawyer, but at the same time I was managing buildings for a management firm. We used to say that best practice was to put about 15% of the total budget of 1 year within the contingency fund. 5% was not enough. Now today you're forced, according to the law, to have a report for the contingency fund, and very soon you will need to abide by the recommendation within this contingency fund. So the question will not remain for long. At this time, it's still 5%, at least 5%, but very soon there's going to be a modification to that article, and you will need to abide by and obtain every 5 years contingency fund report and follow the recommendation. So very soon the question will be moot.
Thank you. All right, so I promise this is the last one. So can the board of directors fix a penalty fee for infringements like tardiness in paying condo fees or not taking out the garbage? If so, do these penalties have to be added to the declaration or the bylaws?
Yeah, like I said earlier tonight, before January 10, 2020, you were able to put penalties in your declaration of ownership by amending the bylaws of the Immovable. Since January of last year, it's not possible no more. You need to amend the Constituting Act. If you want to amend the Constituting Act, it needs to be in minutes. it needs to be notarized, it needs to be published at the Land Registry Office, and the majority in order to create those stipulation is greater. Now it's 75% of the voting rights of the corners present or represented, while before modifying the bylaws was only 50% of the corners present or represented. So it's way more difficult. But should you get the majority, should you have the resolution voted by the general meeting, should you obtain the proper majority, should you go see your favorite notary and have this notarized and published in the Land Registry Office? Yes, of course. But again, penalties needs to be proportionate. If they're not proportionate, a tribunal, the court might decide to lower or to cancel such a penalty. Now, it can also, it's not also, apart from this, I need to let you know that it's applicable for not respecting the declaration of ownership and some part of it. But aside, you cannot charge a penalty for not paying your condo fees on time. What you need to charge is interest rate. I'm telling you this because some syndicate of ownership will put an extra fee of, let's say, $25 if you don't pay your condo fees on time every month. But by doing so, it might be greater per year than 60%. And 60% or over is a criminal interest rate. So therefore, you need to take this into consideration. If ever you charge this at the fixed price, this fixed price shall not be more than 60% per year.
Thank you very much, Maître Fisset. So I'm going to say that we're going to stop here. I know it's disappointing. There's still so many questions, but I've just put in an email address where if your question wasn't answered, feel free to send your message there, your question there, and we'll get you an answer as best we can. And I would like to thank you, Maître Fisset, for your time and for this great presentation. I want to thank again the Chambre des Notaires for making this webinar possible. And so I invite everyone to remind everyone that the last webinar in this series is happening next week, next Wednesday, August 25th, again at 5:30. And we've already put the link in the chat, but I'll do that again. If you haven't already registered, as you can see, these are quite popular. So I'll put the link in right now so you can go there directly. And with that, I will bid everyone a good evening. Thank you everyone for your time.
Thank you. Good night, everyone.